Professor Trassow, who's going to talk a lot more about contracts and subscription licenses.
Okay. What I want to try to do in my talk today is pull together some previously unrelated strands. We tend to talk about copyright separately, and we talk about open access, we talk about textbooks, we talk about campus policies, and I want to put forward what I call a holistic approach to all of these things, and recognize that you can't really create a good information flow on your campus that is user-friendly and very, 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 very interested in open access without considering policy implications in copyright and related to open access and related to textbooks. So we thought that this presentation this week in honor of Open Access Week, which it is, would cover a variety of different issues. Just walk through the bookstore and see what's going on. And yes, if you're a calculus scholar, calculus is going to change over a period of time, and at the upper levels there's going to be research happening, but not in the freshman calculus course. Same thing for French. Same thing for studying Aristotle. Same thing for all the things that we do in the first year. And you walk through the bookstore and it's just so sad to see those books sitting there. Packages are over $200–300. I'm not talking about somebody putting out a paperback for $24.95, which happens to be the price of my book. I'm talking about packages that cost like $300–400 in the case of some of them. I'm supposed to talk about copyright. I'm not going to spend 15 minutes reiterating what Lisa said. There are different policy venues for copyright policy formulation. Certainly there's the legislature. And we've spent the last couple of years, since 2002, with Bill C-61, with the consultation, with Bill C-60, with Bill C-32, then the government fell, and then came back with Bill C-11, and finally Parliament passes copyright reform. And we have that now, and that's closed. And while there's some bad parts of the copyright legislation, there's some really, really good parts of that copyright legislation too. For example, adding the word education to the fair dealing criteria. The other big policy venue is the courts. And over the last few years, there's been a lot of litigation. And in 2012, the Supreme Court came down with the pentology. Five cases dealing with review of copyright board decisions. And again, this pentology, and Michael Geist has just released an entire collection on articles about the pentology. Very, very big policy. Really upholding users' rights, upholding fair dealing in very, very clear terms. So when we think about where copyright policy is being made, I want to now turn our attention to local institutions. Parliament has spoken. The courts have come down with some very, very serious decisions. And where the action is now is right here. And the nice thing about understanding that copyright policy is made in local venues means we can all take a little bit more responsibility. You're all not going to make it to the Supreme Court to do oral argument. You're not going to make it to Parliament to sort of deal with legislatures, but you're all policymakers now on campus. And this also means we have to take more responsibility for what goes on in our own local institutions. So I argue that there are three closely interrelated policies on campus that can have a significant effect on the policy environment, the open access environment, the information ecology, so to speak. Campus copyright policies, the licensing that we engage in, and the overall education effect. And what I'm calling for is a unified approach that yes, our licenses are important. We have to start being more discerning about the types of agreements that we enter into. I'll give some examples. Obviously, access copyright is a big one at the top of the list, but it's also the smaller ones too, with individual publishers, often negotiated through consortium. There's the problem of what are the campus copyright policies. Lisa DiValentino has just done a study of the AUCC institutions across the country, and she's compared different university copyright policies. It's important that your university has a copyright policy. Western is lagging behind a little bit, but I understand that steps are being undertaken as we speak to remedy that. And the other thing that has to happen is more attention needs to be given on every college and university campus to copyright literacy and sort of licensing literacy. This is not something that's just for the lawyers. This is not just something for copyright scholars. This is not just something for people who are actually in the higher levels of library management who might be negotiating contracts. We all have to understand the implications in our day-to-day work. This applies to faculty, this applies to librarians, it applies to students. Now, I think there are three persistent barriers to progress. We've got new legislation that's helpful. We've got a string of court decisions that are helpful. We've got at our I'm supposed to be doing this. Okay, so three interrelated issues that act as barriers to this quest for an ideal copyright environment. And one is undue risk aversion. Yes, we don't want to be reckless. We don't want to be encouraging faculty and staff to be engaging in actionable copyright infringement. We don't want people going to the bookstore and buying one book and then going to the library and scanning it and then distributing it to their students for, instead of $150, maybe selling it for $50. We don't want people engaging in what's clearly actionable copyright infringement. At the same time, at some point, you have to let go of your risk aversion and say, we are going to exercise the rights that we have under the copyright law. And what we're starting to see now, after the Pentology, is that on some university campuses, this is happening at a quicker pace than in other university campuses. And again, I will say that our university does not rank among the more proactive, progressive universities across the campus. But again, that may be something that's in the process of changing. So that's the first persistent barrier, undue risk aversion. Ultimately, to the point of causing rights accretion. Because what the Supreme Court has said, when you do your fair dealing considerations, custom and practice in the industry can be taken into account. So when the university engages, when a major university engages in undue caution, that's creating part of a record for custom and practice. And when you have the National Association representing universities, in this case AUCC, sending out guidelines and asking universities to adopt them, which I hope they don't, which I don't have time to discuss in my remaining 7 minutes. But when you've got AUCC sending out guidelines saying, if there is a clause in a contract that conflicts with users' rights under copyright, you're going to go with the clause. You don't need to make that concession. And by making that concession ahead of time, you're helping along this problem of rights accretion. So, barrier 1, undue risk aversion. Barrier 2, aggressive overreaching. Very aggressive overreaching on the parts of rights holders, vendors, publishers, licensors, and their representatives and collectives. So some examples of this is really hardcore bargaining tactics, where you are going to take these provisions or we're going to walk. Threats. Several universities have been threatened over the years. And I think the best example of aggressive overreaching on the parts of vendors and collectives is the lawsuit that Access Copyright filed against York, which they're now forced to, as frivolous as many of us think that lawsuit is, they still have to expend efforts in defending that. And it does have somewhat of a chilling effect on other campuses who, every time they express a willingness to sort of stick their toe in the water a little bit, they just see something floating around in the water that they don't like, and they pull it out and they say, oh, no, we're just going to be real safe about this. The third persistent barrier to progress is lack of copyright literacy. More people need to know more about copyright. And lack of contract literacy. More people need to know more about licensing terms, which does not mean that you have to go to law school and take a whole year course in contracts or take copyright classes. This is something that's within the ability of people who are trained in librarianship to deal with. And we take that portion of the training here in FIMS very seriously. So the negotiation of licenses. At the institutional level, and also the consortia, who often negotiate on our behalf. These licenses sometimes are unnecessary. So if all you're getting from a license is the right to do something that you already have the right to do under fair dealing or some other provision, then what value are you getting from the license? In other words, it doesn't matter whether the access copyright license is $26, $24, or $18.92. So if the university comes back and says, well, we've negotiated down the cost of the access copyright license, and this is a wonderful cost savings to students, you're still not getting anything that you don't already have. So what they give us needs to increase. Or as I say in another talk, a bad deal at any price. You could cut the cost down to 2 cents and it wouldn't be worth it because you're not getting anything and you're taking on all these other liabilities. The negotiation of licenses, which is unnecessary and only grant us back rights that we have, needs to stop. We should be paying for things that we need. The next point is license terms that have provisions that are derogatory to users' rights, that are contrary to public policy, and they contain terms that sort of limit what you're allowed to do under the law. Our negotiators who are acting on our behalf have to say no. They have to stop agreeing to these terms. That also means, by the way, the faculty members need to understand that some of their journals may get cut off temporarily, and a lot of work needs to be done with faculty members as well. The more restrictive and directive your campus copyright policy is, the more it feeds into these other problems. So my third point is that the second point, is the campus copyright policies need to be flexible. They need to be flexible. So my 3 strategies for overcoming these barriers: terminate the current unnecessary agreements, and sometimes you have to wait till the end of the contract term. Don't enter into new ones that just reproduce those problems, and recognize that rights accretion is built into our contracts. And when we do something at University X that's derogatory to our rights under law, it has a negative effect on University Y, as well as all the constituents of University X. A full discussion of the adoption of institutional copyright policies, which are flexible, which are educative, and which are user-centered, is well beyond the scope of my talk today. But I just want to highlight that this is a highly current and highly charged issue. Well, with AUCC now having sent around a very, very bad set of guidelines, and I very much hope that this university rejects the AUCC guidelines and instead adopts something along the lines of what the University of Toronto or what's been put out by CAPT has adopted. And also much more needs to be done about promoting copyright literacy. So here it is, just say no. This was a big deal in the 80s, and I think we need to make a big deal out of it now. For every potential license, ask what you're getting, and if you're involved in negotiating a license, at some point you have to say, no, we're not going to agree to that. Fair dealing is not simply a technical defense to copyright infringement. It's a fundamental user's right that's an integral part of the Copyright Act. This is the Supreme Court on several occasions saying this. Do you have the authority as a negotiator to give up fundamental rights that your users and faculty have? And I would say no. And this has to be taken up at the level of consortium. Say no to onerous terms. And I guess what wins the prize for the most onerous term, I don't know if you, gentlemen, you can't fight in here. This is the war room from Dr. Strangelove. Well, faculty, you can't use this for a course. The license did. This is a university. And it makes about as much sense. Harvard Business Review. License, you're paying a lot of money for it, but you can't use it for assigned course material. Someone agreed to that. We're paying money. We're paying student funding, the taxpayer money. We're paying money for a license that tells us at a university you can't use this in course instruction. Why would you agree to a license term like that? Well, the answer is they'll walk, and then you've got angry professors who say, I need this for my course. So, the faculty need to take some responsibility here, too. But this is probably the worst license I've been able to find. and there are others that are a little more moderate that still have terms in them that are not helpful. Lots have been said about these new copyright policies. Here are some sources you can look at. Copyright literacy needs to be improved. Every campus needs to have a copyright officer who, as part of their job, and I've got some additional materials on slides that I'll just sort of every copyright officer needs to be proactive in terms of consulting with people across campus and dealing with not just copyright issues, but also open access issues. The copyright officer and those working with the copyright officer need to really worry about transparency. And you can look at this material in some greater detail because my time is up. But here is this is not a full literature review. Paul's actually done one, and we'll get it posted in Scholarship at Western. Here are just some ideas to look at. Lisa's report on campus policies, my report on the access copyright license, and watch Scholarship at Western for additional materials, because that's where we like to post things, because it's an open access, freely available